All right, so last time we were present on the motion to reconsider. I took it under advisement. Then after additional review of ultimately the transcript and the things that Mr. Arnold had represented, I issued a minute order requesting additional information from AG Entertainment that the money they paid Cash Jones was for previous work as Mr. Arnold represented, as opposed to some other purpose. On 7/29, Mr. Arnold provided an invoice from Mr. Jones with no acknowledgement from AG Entertainment that they received it or that the items on it were paid for those items. I think that was shared with both parties. Then the court asked for something from AG Entertainment, specifically that the $112,500 was paid for work done by Mr. Jones previously. Like I said, that had been represented by Mr. Arnold. And then I received the following letter from an Adam W. at AG on AG letterhead on 7/31. It stated, we received the invoice dated June 1st from 100 Entertainment Incorporated. On June 11, 2024, we sent a wire of $112,500 to 100 Entertainment Incorporated for this invoice, admin Adam W. And then there was a number and an email. So I had my law clerk call and email numerous times, left several voicemails. We never received a response from Mr. W. Then on 8/2, I received another letter from a Shonya Pittman Roach. We did research her and did find that she had a connection to AG Entertainment, but her name was ultimately misspelled and the address on the letter returned to a doctor's office. So the letter ultimately said the exact thing verbatim as what we had received from Mr. W. Which was, we received an invoice dated June 1st, 2024 from 100 Entertainment Incorporated. On June 11, 2024, we sent a wire of $112,500 to 100 Entertainment Incorporated for this invoice. Regards, Shonya Pittman Roach, Director of Operations. The law clerk again attempted to reach her via phone number numerous times, left voicemails. There was no email to reach out for, but ultimately we did not get a call back. Mr. Arnold then reached out to our office approximately August 13th and asked us what was going on. Why weren't we contacting these people? We informed him we had been trying. We hadn't gotten any response. But at that point, upon Mr. Arnold's urging, we recalled the two numbers that we had. Ultimately, my law clerk was able to talk to Ms. Roach. She did tell us that there's no Adam W. who works there. She doesn't know who sent that first letter. We asked her why this was identical language that was included in both letters. She indicated that Smiley Bail Bonds reached out to her and told her what to write. She forwarded us an email from them indicating that 100 Entertainment received a wire from AG Touring in that amount on June 11, 2024. We just need letterhead or an email from you, AG Touring, representative or accountant for this company acknowledging the transaction. No other details need to be explained, as AG Touring has no involvement with this transaction. The purpose of this verification is solely for the source of funds. Below is a statement we already provided the court. Please use the same language as nothing further needs to be explained. Appreciate your help and understanding. And then it contained the identical language that we received from Mr. W. and that we received from ultimately Ms. Roach. And so at this point, ultimately, I still have a lot of concerns about what has been sent to me. And that's why I haven't issued any further orders. I had hoped to address this last week, but ultimately Mr. Arnold wasn't available. And so we'd set it to today's date. And so that's kind of what I hope to get to the bottom of today. Concerning to the court is that I don't know who Adam W. is and why other people in AG Entertainment are indicating that they don't know who this person is, if he did use, in fact, that AG letterhead, and ultimately why there seems to be sort of this obfuscation of why AG is giving this money and the direction ultimately not to give me any additional information. So, Mr. Arnold, that's sort of what I wanted to address today and get to the bottom of, to see if ultimately these are funds from a legitimate source, and we can proceed with this release. So, Mr. Arnold, what do you want to respond?
Yes, Your Honor. I forward to the court a letter from Smiley Bail Bonds. They advised me that, again, similar to what Ms. Roach told you, that they were the ones that put together the letter. It's my understanding that there's no Adam W., that what was supposed to be admin email was misspelled, or autocorrect was used and it kicked out Adam as opposed to admin. The other thing that I'm aware of is that Ms. Roach, like you said, I believe, contacted you and told you she was the one that personally did the wire. However, they do not want to reveal the different concerts and the individuals involved, simply because of repercussions that they may have in doing further business with those individuals. Obviously, no one wants to be directly related to providing monies to bail out Mr. Davis. But again, these were monies that were given in payment to Cash Jones, and Cash Jones utilized the money how he deemed fit. Lastly, Your Honor, I'm also aware that Mr. Jones, again, because of his involvement in testifying at the last two court proceedings ago, that he's been receiving death threats. So
Mr. Arnold, your cell phone cut out?
That's muted, Your Honor.
Oh, you muted yourself, sir.
sorry about that, Your Honor. But again, Smiley Face Bail Bonds is on line and can give further explanation in regards to the letters. That's all the information that I have before.
So the last thing I said that you had said before you cut out was that Cash Jones has received death threats. What ultimately was the relevance of that? Because I think I might have lost the end of your argument on that.
Oh, yes, Your Honor, that Cash Jones no longer, wants to give testimony or, show, the public that he's involved in this any further than he has. So, and then I went into Smiley Face Bail Bonds owner is able to discuss the actual letter received from AG Entertainment.
Okay. State.
Your Honor, first, as an officer of the court, I would advise the Smiley Court Bail Bondman not to testify, not to give a statement, because after seeing his letter, it appears that he submitted a false document to this court, which is a felony, which the state takes very seriously. In the letter that he just provided, he said, "I cut and paste the body of this thing and then sent it to you for the purposes of meeting whatever this court's requirement is." And uttering that instrument to this court in that manner is a felony, and I think the state takes that very seriously, especially from a bail bond. So as an officer of the court, I think it may, be advised that that will not go uninvestigated, that statement, because state believes he admitted to committing a felony in that statement. Number one. Number two, I'm not surprised that Cash Jones doesn't want to come here and testify, given how his testimony came off last time. He absolutely lied to this court with regard to his representations as to why he was providing the funds and where the funds were coming from. It was demonstrably false testimony. And so, Your Honor, I am not surprised that when this court tries to look under the rock from where this money is coming from, this court gets more fraud. And when this court pursues, well, where does this money come from? This court gets more fraud. And then when Mr. Arnold has the bail bondman try to explain what he did in altering the document that was submitted to this court gets more fraud. This court has already ruled that or at least has ruled that this court is willing to consider the source of funds, but it has to be a legitimate source of funds. And when we are obfuscating the source of the funds, it's a clear violation of this court's order. It is most fundamental. It should be fairly easy to say this is where the money comes from. Additionally, if this court were to consider this, to want to keep on pulling up the rocks to see where all this fraud is coming from, it defeats the purpose of the source hearing to have Mr. Jones say, yeah, I got this money from this person and that's where I'm spending it, without us getting to talk to and having sworn testimony from this person from which the source emanates from. So I think at the very least, the bail bondsman is not the correct source for the source of funds. It is the person from whom the invoice is coming from, which is the correct person that we would need under oath to testify about the validity of the source of funds.